morning. This is Wendy from Cohen Tucker. Hope everyone's doing well this week. I'm going to be speaking to you today a little bit about embassy operations, as well as the importance of discussing criminal arrest with your immigration attorney, and the importance of getting records when you've had prior immigration cases. So first, let's start with an update about embassy operations. Quite frankly, it's a mess. I wish it was better news. The good news is embassies are operational. Not all, but a lot are operating. The bad news is they're not processing cases as quickly as most people would like. And in some instances, they're not even scheduling interviews for certain types of cases. We've had a lot of employment-based cases struggling to get interviews lately, and it is difficult. One thing that we also are seeing a lot of is what are called third country national interviews. So, for example, if you are from a country where the embassy is closed or only open to emergency appointments, in theory, you could ask to be interviewed in another country where you could legally enter. The issue is that a lot of these embassies are either not taking third-party nationals, or even when you're able to get an interview scheduled, you face cancellations because of ongoing COVID-19 issues. For example, we recently got a case scheduled for an interview in Romania. It took an extremely long amount of time to get to that stage, only to have an email sent that the interview was canceled. When we requested an emergency appointment, we were told that emergency appointments in that country were only for citizens and residents of the country. So, with that being said, it's frustrating. We understand. We're frustrated too. We're trying to work through it the best we can, locate places where interviews could happen, inquire about statuses of cases that have been pending for, like, documentarily qualified for a while, and we just can't get interviews. So understand your attorneys are probably just as frustrated as you are. Things that you can do: if you do have grounds for an emergency appointment, you can certainly request one. It's not guaranteed to be granted, but you can try. If you can get an emergency appointment, your family member or your employee may be able to return to the U.S. sooner. On a positive note, in November, it looks like some of the travel restrictions will be lifted, meaning that we will not have blanket bans on people from certain countries anymore. They will be required to have proof of vaccination or a recent COVID test. So those people with visas who have been unable to travel because they're from a banned country will at least be able to enter the country. So that will hopefully help with some of the tension that's going on right now. Okay, next topic. So the next topic is arrest. If you are a non-citizen and are arrested for any crime, or, for example, cited for a drug offense where you're not actually arrested but you're given a ticket, it is extremely important that you consult with an experienced immigration attorney. If you have an attorney, great. Go tell that attorney right away that you've been arrested, what for, and if you have a criminal attorney, make sure the criminal attorney knows about the immigration attorney and the immigration attorney knows about the criminal attorney. It's very important that you keep your attorney in the loop. We get a lot of people who are like, I've been arrested. Months later, after the fact, they've already pled guilty, and the guilty plea is a problem because a lot of times the goal of the criminal attorney is to minimize the actual punishment, whereas certain convictions can make you ineligible for immigration benefits. I frequently hear, but it was just a misdemeanor. It doesn't matter if it's a misdemeanor or felony. It could still be a potential problem. So you should really talk to your immigration attorney as soon as you've been arrested, and definitely before any plea agreement. It's usually best to have the criminal and immigration attorneys talk to each other so that both understand the potential sentences or outcomes as well as the criminal attorney can understand the immigration consequences and may be able to take that to the DA to change the offer that would minimize consequences. Because if you're convicted of certain crimes, you can be barred from immigration benefits. Sometimes you're eligible for a waiver still, but other times you're not. For example, a possession of controlled substance, aside from simple possession of marijuana, can be extremely difficult. It makes you inadmissible, and there's no waiver for it. There is a waiver for one simple possession of marijuana. So if you've already have a conviction involving marijuana, you have to be very careful about getting a second one. Beyond that, things like shoplifting. I hear that. Shoplifting, not too bad. It was just shoplifting. Except for you get 2 of those, and now you need a waiver because you have 2 crimes involving moral turpitude. So please, just reach out to your attorney. If you don't have one, contact an attorney. Many attorneys will either do a free initial consultation or offer you a fee to review the criminal documents, speak to your criminal attorney, and try to work out what's best for you to minimize any consequences. And the last topic today, getting records. We often see people who have come to the office who've been here for years and may or may not have filed immigration cases, may or may not had encounters with CBP, that's the border agents, as well as the people at the airport, or ICE, and they know something about the case, or they don't quite know what happened, but they really want to file because now they're married to a U.S. citizen, or their child just turned 21, or they have an employer who wants to sponsor him. There's a lot of things that come up in the future, and people want to take advantage of it. And that's great if you have the ability to get legal status here. That's fantastic. But the biggest thing that you need to keep in mind is if you have a past history, it's important to have that history reviewed before you just go filing a new application. Time and again, we see issues created because people didn't disclose something on an application. For example, if someone crossed the border without the U.S.-Mexico border without inspection, meaning, what people typically call illegal entry, they may encounter CBP officials, and they may tell those officials they're from Mexico when in fact they're from Guatemala or Ecuador or Peru even. And what happens is that they're able to voluntarily return to Mexico, so there's no deportation record. The problem is that later on, when circumstances change and they're applying to get legal status here, they now need to deal with a potential misrepresentation because effectively they lied to immigration in order to be able to voluntarily return. And that is a serious problem. It triggers a permanent bar that can only be waived if you have a U.S. citizen or LPR spouse or parent. Now, that's one reason it's important. 2, I've worked on other cases where there's multiple statements submitted and none of the statements add up. There are similarities between them, but at times there's not, or there's a big event that was not listed here but is listed here, and it doesn't mean the person's being untruthful. It just means that it's going to raise questions, and so you need to be able to prepare ahead of time and be prepared to deal with those questions so that you can present the case the best way possible. There's also situations where someone's just simply not eligible. They're now married to a green card or U.S. citizen. They're applying for their green card. They file all the applications, go to an interview, and they're not eligible for the green card because they've been ordered removed before. Whether it's an expedited removal order or an in absentia order. And Now you've spent time and money, and this isn't your path. You need to do another path to get status here. So it's very important that if you've been here for a long time or have had any encounters with immigration officials, that before you file any kind of application, you get your records and you have them reviewed by an attorney. We do this as a matter of policy when anybody comes into the office and they tell us about prior removal proceedings or previous applications with USCIS, because we think it's important to know what was done and understand why an application may have been denied, or a request for evidence sent, or a notice of intent to deny sent before we file a subsequent application. So just keep that in mind. Yes, it does make your case take a little longer, and I understand that is not always what people want, but in the end, if it saves you another denial or allows you to realize, oh, I need a waiver, let me file it now, instead of waiting for immigration to realize I need this waiver and ask me for it, it ultimately will save you time and frustration. I hope you found the information today helpful. I hope you have a great rest of your week. Thank you for listening. And if you have any questions, please call us at 212-840-0050. Thank you. Have a good day.